Now we proceed to Article 129, search warrant maliciously obtained and abused in the service of legally obtained search warrant. The procuring search warrant without the elements of securing search warrant without just cause is that the offender is a public officer. Again, he procures a search warrant and there is no just cause. Now, what is a just cause about procuring search warrant? That the witnesses to the crime allegedly committed or to the illegal items allegedly can be found committed perjury for the judge to issue a search warrant. Say for example na ay magtumutumo di sulti nga na si Pedro na ay almas and then naa kay witness when in fact and in truth si Pedro walay almas, so the witness committed perjury. The means of securing a search warrant is without cause. So you are liable for that. The witness is liable for perjury. That is the essence of Article 129, procuring search warrant maliciously obtained. And second act punished under Article 129 is that exceeding his authority or unnecessary severity in executing search warrant legally procured. Again, the elements in second paragraph or second act punished under Article 129 is that the offender is a public officer. He has legally procured a search warrant, but he exceeds his authority to or uses unnecessary severity in executing the same. Now, the second paragraph or the second act punished under Article 129 is that na search warrant legally obtained, but the search warrant nasubraan pag execute. Example, if the search warrant is for the car, the crime that allegedly committed was carnapping. The search warrant is for the car that may be found in the residence of the subject of the search warrant. Now, if the subject of the search warrant is a car, you don't go inside the room and search the cabinets, the doors, search the bedrooms, the cabinets, the locked doors, the jewelry chest. That's unnecessary severity. So, if the search warrant is for drugs, so syempre, imo nang buting-tingon ang lugar, ang kwarto, ang cabinets, because the subject of the search warrant is a small piece of illegal substance. But if the subject of the search warrant is a car, you don't go inside the room or the cabinet. The car cannot be fit in the room or cabinet. You go just plainly seeing the residence. You will see if the car exists or not. Moving on, Article 130, searching domicile without witnesses. The elements of the crime is that the offender is a public officer, he is armed with search warrant, legally procured, and he searches the domicile, papers, or other belongings of any person, and the owner or members of his family, or the two witnesses residing in the same locality are not present. So, na search warrant, you have to know when to execute a search warrant with witnesses or when to execute search warrant without witnesses. So if na ang tagbalay diya, subject of the search warrant, you can search in his presence. You cannot, or you don't have to secure your own witnesses. Now, if wala diya ang subject to search warrant, now that's the time you need two witnesses required by law. Anyway, in cases of search warrant involving police officer, they usually have two witnesses already secured. Two witnesses already, which is not member of the household. Because to be sure, you have to have witnesses during the implementation of the search. Now, again, as I've said, if naadi ang tagbalay, subject of the search, you don't need witnesses. But if wala, the law requires witness from the residents from the locality. I think the law requires the local barangay officials to witness the search warrant. I will go back to that. I will look into it, the specific witnesses for the search warrant. Article 131, prohibition, interruption, and dissolution of peaceful meetings. This provision is self-explanatory. The offender is a public officer that he performs the following acts: the prohibiting or by interrupting without legal ground the holding of a peaceful meeting. So you have to take note of peaceful meeting. If the meeting is violent, if the meeting is amounted to rebellion or sedition or insurrection, then you have the right to do so, to stop or to interrupt that meeting. Another act is hindering any person from joining any lawful association or attending any of its meetings. So, kung ay mag-meeting diya, dili na pwede nimo interrupt. Kung dili na, kung peaceful na or lawful. Prohibiting, last is prohibiting or hindering any person from addressing either alone or together with others a petition to the authorities for the correction of abuses or redress of grievances. Now, these acts, you may find this in cases of protest made by, say, for example, a concerned citizen, protest by an individual or a group against government actions. These protests are lawful, are guaranteed, protected by the fundamental law of the state, the right of the person to petition to the authorities or for redress of grievance. You should already know that. Kanang magprotesta sa action sa gobyerno, that's totally lawful. Now, if magsugod na og pangguba, that is not protected by the fundamental law of the state. The fundamental law of the state states that peaceful, the petition to the authorities and redress of grievance should be peaceful. So if nanay magguba diya, mangdaot sa government properties, public place, that is not covered by law. They may be liable, they may be arrested. But all in all, the protest to the actions of the government, perfectly legal. They can march, they can rally, they can do anything to petition the government to place of grievance, ipagawas nila ilang mga kasuko sa government actions that is perfectly allowed by law, that is guaranteed by the Constitution, that is the right of a citizen. Moving on to Article 132, interruption of religious worship. The offender is a public officer. There is a religious ceremony or manifestation of any religious are about to take place or going on. The offender prevents or disturb the same. So, public officer gyapon, iyan ang interrupt or prevents the ceremonies, religious ceremonies. So, dili kada pwede maghilabot anang religious ceremony. How about COVID restriction? Can you interrupt? Can you interrupt the religious worship because there is COVID prohibition? You have to look into that. If I say lockdown, and then a priest anyway conducted a mass, can you interrupt the mass and say that there is COVID restriction? Look into that. Article 133, offending the religious feelings. The acts complained of were performed in a place devoted to worship or during celebration of any religious ceremony. The acts must be notoriously offensive to the feelings of the faithful. In the essence of this crime is that you deliberately gituyo nimo na kay intensyon nga daoton ang feelings sa faithful nga ning attend sa isa ka lugar during religious ceremony. So, imuha ng daoton. Yes. Pasakitan kay nakailaing agenda or nakailaing tinuhuan. So, ni-express kasi mong tinuhuan with an intention to hurt the feelings of the faithful worshiping in that area that you don't like. Again, you are a public officer. You don't have the right to offend someone else's religious feelings. That is their right to believe what they want to believe, and the right to be left alone. If nakakailaing tinuhuan, imuha na sila, ilapot na, just respect, especially when you are a public officer or employee. And that's it for Article 124 until Article 133 of the Revised Penal Code. That's it for the crimes against the fundamental laws of the state. Next time, we will proceed to crimes against public order. Good morning.